be in a greater emotional situation than somebody else, and they have no power to say no. About 3 years ago, there was an individual in South Florida who was arrested because he had his elderly father living in one of those sheds in the back of his house, and every day when he went to work, he would lock him in, and the man would stay the entire time in that shed until the man arrived at night, and then he would unlock it, give him food, and that was it. During that period of time, that son, because it was his father, exercised not only physical duress on his father, but also emotional duress because the man didn't have any place to go. So duress doesn't necessarily always have to be physical. An undue influence is a relative of duress. Undue influence means that you rely on my judgment. And I utilize, knowing that, I utilize that reliance to your detriment. Okay? You expect me to give you good advice, and I know that you expect that, and I tell you something that is going to be detrimental to you and perhaps beneficial to me. Okay? I want you to invest in this. Knowing it's my company, it's losing a shirt, but your investment is going to make me some money. A stockbroker, a lawyer, a business acquaintance, somebody that knows that you're relying on them, and they utilize that reliance to influence you in an inappropriate way. Unilateral mistake made by one party to a contract and mutual mistakes. Okay? A unilateral mistake and a mutual mistake. A unilateral mistake is when one person believes one thing and the other person believes something else. And a unilateral mistake is the other person understands what the deal is and one person just misunderstands it. What is the effect of it? A mutual mistake is when they're both a misunderstanding as to the nature of the situation. Mutual mistakes. Courts do not find these enforceable. Mutual mistakes, you and I have two separate understandings of what the deal is. When I was going to law school and I was sitting in this class and I thought that this was boring too, my teachers talked about a deal where a company was going to ship goods, and they went to a shipper, and the name of the case is A Ship Named Peerless. And both the shipper and the shipping company had a misunderstanding as to where the goods were going to be shipped. So they sued each other. You didn't pay me for shipping your goods, and I didn't ship your goods to where you wanted them. So, because there was a breach, so we're both claiming, but the court found that because on the day that I took my goods, there were two ships named identically. Shipper thought my goods were going in this ship, the shipping company thought the goods were going in that ship. There was not an understanding, there wasn't a meeting of the minds, and therefore a mutual mistake invalidated the contract. Neither party could recover from the other because there was a mutual mistakes, we're going to call them honest mistakes. Honest misunderstanding. We both thought different things. Unilateral mistakes, general rule, has no effect on the validity. You go to a garage sale. The people are selling baseball cards. You look at one, and it's Babe Ruth. And they're selling it for $100. And you say, wow, I saw that card. I saw it on television, and it was selling for $10,000. And it's only going to cost me $100. So the seller knows that it's a reproduction. It isn't the original. They still want $100 for it. You buy it under the false misunderstanding that it's a $10,000 card, and then you learn the truth, that it's a reproduction. This is getting old.
No, come back.
Did it come back?
Yeah.
So, when only one of the parties misunderstands what the deal is, you still have a contract. Okay? When both of the parties misunderstand the deal, there's no contract. Now, because this is deductive reasoning, because you're looking at the circumstances to determine the agreement, when there's a written agreement, the written agreement is an easier, not perfect, an easier way to determine what the deal was. So the law says, look, when there is a writing, we're going to rely on the writing to the extent that the writing is clear to determine what your deal was. We're not going to let you say that if it says blue that you intended red, because then it becomes very difficult. The writing is better evidence as to what the parties intended than what the parties want to tell you afterwards. So, when contract specifies what happens in the case of a mistake, the contract will apply the law if the law does not. Contract is what parties agree to orally, even if written says something else. Now, generally when there is a writing, the contract is what the parties agreed to, but the writing is going to be the better evidence. Let me say that again because it's difficult to understand. An agreement is a meeting of the minds. Is the meeting of the minds in writing? No. It's somewhere between your ears. That's what the contract is. Okay? The writing is evidence of the contract. Okay? So, in true nature, the contract is what the parties agreed to mentally. But the better evidence as to what they agreed to, not the only, the better evidence is what is in writing. Do you understand the difference? Okay. Unilateral mistakes generally have no effect on a contract. A unilateral, you can't go back and say, give me back my $100 for the card, because I thought it was $10,000 and it wasn't. Has no effect, you still have to pay the $100 and it won't be given back to you. Mutual mistakes generally will make a contract invalid. Let's talk about voidable contracts and void contracts. A void contract is an agreement where there is absolutely no enforcement. Neither party has any rights. There's no agreement. A voidable contract allows the parties to say, yeah, there's a problem, but we're okay with it. Okay? There's a problem, but we're okay with it. Okay? A mutual mistake makes the contract invalid. Is an invalid contract void or voidable? Void. Okay? Which means that there's no contract to begin with. A voidable contract, there's a contract, and one of the parties has, or both of the parties have an option to get out. An invalid contract means there's no contract. Okay? Exception. Now, mutual mistakes, and this is something fairly new. Fairly new means before you were born, but in the history of the law, kind of more recent. Which means, look, if there's a mutual mistake with regards to the value of something, because valuation is something that a court can do by taking evidence. We're not, and everything else in the contract you've agreed to except for the value, the court says, look, we can determine what the fair value of something is. We can determine what the quantity is by taking evidence, and therefore we're not going to say that that's going to invalidate the agreement. Same thing with regards to price. A mutual mistake of law and expectations. Mutual mistake of law does invalidate the contract if the law makes the contract from legal illegal. Now, if you were going to bet on what's that betting service? What is it? No, there's a website that you can. FanDuel. If both sides are under the impression that FanDuel is legal in the state of Florida, and I don't know where we stand with regards to FanDuel. I know that some states stand for the proposition that they're not. And it's illegal, well, that misunderstanding of law will make the contract still illegal. Okay? However, if you and I have a misunderstanding that the law is going to apply this way versus that way, that misunderstanding of the law might not invalidate the contract. Okay? Also with the expectations. You know, I'm entering into this agreement with you because I think I'm going to make $1 million. And the reality is I'm going to go broke. It does not invalidate. Even though you think I'm going to make $1 million and I think I'm going to make $1 million, it's not going to invalidate the contract. Okay? Fraud in the inducement. There's two time frames where if I give you a fraudulent situation, you have to ask yourself. Okay? There is fraud in the inducement. I've induced you I've gotten you to get into this contract by means of fraud. Okay? I sold you a story that isn't true. And I don't know if I gave this class the example of the miners that used to pepper their mines. Did I give you that example? Okay. During the time of great mining in the United States, more people became rich not because of finding gold. They became rich for selling stuff to miners who were kind of, hungry for the gold. And there were some people that were very smart. They didn't find gold. What they found were mines that didn't have any gold. But what they did was this. They bought some gold. They didn't mine it. They bought some gold. They then got shotgun shells. They took out the pellets. They put the gold in the shotgun cartridges. Then they went into the mine that had no gold in it. And then they began shooting the walls. Okay? You're thinking, that's a waste of gold. It isn't. Wait for it. So now, they let on that they found lots of gold. So the other miners are interested. They then let on that somebody in the East Coast, because they found gold in the West Coast, in their family is very sick and you have to leave. Because they're on their deathbed. So you're desperate to sell this mine at a loss. Because it's got all this gold. And you bring people over to the mine and they begin to look at the walls. And it's full of gold. And they're thinking to themselves, if this is what I see in the walls, what am I going to see when I start going beyond the walls? I'm going to become rich beyond belief. Okay? And so I'm willing to pay the price that you want for the mine because I'm going to be a multimillionaire, right? I'm going to be up there with Trump. Well, not last night, but I'm going to be up there with Trump. So I've induced you to enter into this contract for the purchase of my mine by way of fraud. Okay? That's fraud in the inducement. Okay? Makes that contract voidable. Which means, why? Voidable at whose option? Voidable at the option of the buyer. The buyer can say, I void the contract, I'm not going to pay you. But why is it voidable? Well, Brazilian soap opera yesterday. There is this novela called Flor del Caribe. I don't know if you're familiar with it. She does. It's the morning, 6 o'clock. My mom does too. In Flor del Caribe, there is an owner of a mine. And I think it's a diamond mine, some sort of mine. But he's selling it. And he's selling it kind of the same type of thing. But the buyers, who this person thinks is getting nothing, knows that in the quartz there's something else. So if I've induced you fraudulently, but you later go in and you find something else, you may still want the benefit of the contract. Hey, I still want it because there is this. A void contract, you can no longer accept that benefit, even if it's beneficial to you. Okay? So, fraud in the inducement, where I induce you, gives you the right to void the contract. I can't. I can't say, oh, wait a second. I know I defrauded you, so the contract is void, right? So I can take the benefit of that stuff on the courts. No. You have the option. Okay? Voidable. Okay. Fraud in the execution. The frauded party did not intend to sign a contract. I'm going to give you an example, and you're going to say that never happens. But I'm going to tell you that I've known at least 3 or 4 different criminal cases in Dade County where this has happened. And this is how it happens. Business person trusts the person that works for them. And on a daily basis, this secretary would bring a series of things for this person to sign. Okay? And generally, all of those things had already been looked at, already been agreed. All this person was doing is signing. Well, unbeknownst to the person that's signing, known to the person that's bringing the document, is a contract that he didn't know about, and all of a sudden, by his signing it, is going to commit him or his company to something. Okay? That is fraud in the execution. You didn't intend to sign it, but you signed it under some